on the Lowdown, a Down syndrome podcast. Ken Kramer gives us the lowdown on wills and estate planning for parents of children with Down syndrome. Over to you, Hannah and Marla.
Hi, I'm Marla Folden, co-host of the Lowdown podcast and speech-language pathologist. With me here is Hina Mahmood, OT and co-host. How are things going, Hina?
I'm good. Thank you, Marla. How are you?
Oh, I'm good. Coffee in hand, ready
to go. Yes, exactly.
Yes,
Excited
absolutely.
for this topic today.
Me too. Before we continue on with our episode, we would love for you, our listeners, to hit that subscribe button and leave a review of our podcast on your chosen podcast platform, whatever that might be. Remember to check out our episode pages for additional resources on each episode. And you can follow the Down Syndrome Resource Foundation at www.dsrf.org and on Instagram and Twitter by following at DSRF Canada. On today's episode, we will be talking about another important aspect of planning for people with disabilities. This is another transitional topic that involves the transition from parents as primary caregivers to other individuals through the wills and estates process. As much as this is a difficult topic for a lot of families, it is essential to plan ahead. And so here to wade through the weeds with us on this topic is Ken Kramer. And in this episode, we'll discuss things like wills and estate planning, as well as other legal documentation involved in the process.
Yeah, so Ken Kramer is the founder and principal of KMK Law, which is a boutique law firm in downtown Vancouver, BC, providing specialized legal services in the areas of estates, trusts, administration, elder law, estate litigation, and mediation for over 25 years. Ken has a unique understanding of the disability community, combined with his expertise in the area of estates and trusts law, to serve families with disabilities. He is extremely passionate and a strong advocate for both the disability and seniors communities and greatly appreciates the opportunity to give back to these important groups. He has served on numerous boards and committees over the past 30 years with a focus on disability and senior issues. One of Ken's biggest passions has been in the area of home care supports and specifically the choices for support in independent living program, or the CSIL program. Ken he has led community negotiations and collaborations with the province of British Columbia for over 20 years. So definitely the perfect person to have as our guest today for this topic. Welcome to the Lowdown podcast, Ken. Thanks for joining us.
Thank you, Hina. Thank you, Marla. A real pleasure to be here and looking forward to this dialogue with you both.
Mm-hmm. Absolutely.
This is an area we want to learn about. So this
absolutely.
Is perfect.
Yeah, exactly. And it is an area where I feel like it may not come up in casual conversation with our sessions, but it's a really nice little thing to have in the back of our brain so we can, help our families and point them to the right direction. So, so Ken, in the grand tradition of our podcast, we always like to start off with what we call 5 secret questions. So there's no math involved. They're fun little icebreaker questions so that Marla and myself and our listeners can get to know you a little bit better. Does that sound okay?
Sounds great.
Great. Okay. So I'll start us off. So question number 1, are you a coffee or a tea person?
Oh, I'm definitely a coffee guy. I've got to have my Starbucks almost every other day at a minimum, and if it's not strong, I just I won't take it.
So you're just like a strong black coffee guy just to get you through the day.
You bet. None of those fancy lattes.
Okay,
nope,
got it.
Get the job done.
Just get the job done. Yeah. Love that. Okay. Okay. Question number 2. If you could listen to one album on repeat, what would it be?
Oh my gosh.
I know it's a hard one.
I'm probably going to go back here, but I obviously a BC boy, born and raised in East Vancouver. So I'd have to go with a local Bryan Adams. So anything Bryan Adams oriented, I'm all around it. Have probably had the chance to see Bryan Adams at least a half a dozen times.
Oh, wow.
Over my life, and never ever regret going to a concert.
Yeah.
And I hope we get to do that more often in the future.
I hope so too.
Soon.
I know I really do miss
Hopefully,
concerts. Yeah.
Mhm.
And he's probably one of those artists that just is consistent every time, puts on a great show. So it's fun to do it every time, right? It's never gets old.
Absolutely. And it doesn't hurt that he's born and raised in BC.
Yeah, exactly. Local for sure. Great. Okay. Question number 3. What was your favorite subject in high school?
I loved
why?
English.
Okay.
I loved English. You know, and I've always been a communicator.
Mhm.
And so communications, it was something I've thrived at, you know, at an early stage. So it's something that allowed me to sort of excel and build on, you know, and develop a foundation, obviously, to, you know, what I do today, which is, you know, communicate and educate and assist and advocate for a variety of clients with a pretty big focus, as you already highlighted, on people with disabilities and seniors in British Columbia.
Mhm.
Well, that's interesting. I liked English too. And it was just occurring to me that it's funny how those things work out. Liking English, you wouldn't necessarily have the absolute direct path, but you're still using those skills, which is really,
Yeah.
I like those things.
You didn't ask the question about what was the subject I didn't like. And
What would that have
so that would have been mathematics. And
Yeah.
I'm still struggling today as my 15-year-old daughter seeks guidance and assistance on math 10 and 11 homework,
Oh,
where
yeah.
I have to deter to those that are a lot more versed than myself.
Yeah.
Mhm.
Yeah. Math 11 was no fun for me either. Bad memories. Yeah.
Yes. And whenever we start this section of our episodes, everyone expects that we're going to ask them random math questions. And that's what makes everybody panic. So, yeah, I think that's a very common.
I always joke, Marlon, you know, that's why I went to law school.
So you don't
I
have to do math.
didn't become an accountant
Yeah.
or a financial advisor.
Yeah.
Yes.
Yeah, for sure.
Exactly. So the next question is, what would be your favorite thing to do on a beautiful BC weekend?
Well, there's so much to do in our community, but having the opportunity to live on the North Shore and being by the mountains, getting out into the parks and out to the beaches, you know, outdoor activities, anything involving greenery and you know, clean air seems pretty positive now.
Mm-hmm. I agree with that.
Yeah.
Try and get out every weekend for sure. And last question to wrap up our sort of 5 secret questions is one thing that you're looking forward to doing the most post-COVID. I have a feeling I know what this answer might be.
Well, I'm a huge hockey fan,
Aha.
so I cannot wait to get to see that first hockey game
Yeah.
in person, in a stadium with other people. I think just being engaged and having been so isolated as we all have been for the past sort of year and a half or
Mhm.
so, just that ability to get out and enjoy life and do things that maybe we took for granted
Mhm.
and now we can appreciate even more.
I think so. And that atmosphere of the first game is going to be
Yeah.
second to none.
And I'm
Exciting.
it's safe to assume you're a Canucks fan since you're a BC boy.
Born and raised, season
Perfect.
ticket.
I was hoping you'd
Season
know
ticket
that.
Otherwise, Hannah's
holder.
going to kick you off.
Absolutely, absolutely.
Great. Yeah, I know. I agree with you. I'm really missing not even like in person for sure, but even watching hockey on TV with fans in the stand. Like it's just not the same with the simulated noise that they had.
So
but
true.
yeah, I agree.
Yeah, the group energy
The
is
group energy.
what's
Yeah.
missing.
Yeah, for sure.
absolutely.
Awesome.
Okay. Well, thanks for indulging us with those questions. It's nice to have everyone understand you a little bit as a person and not just about our professional topics. That's why we do that. But let's dive in here. I'm going to kind of set the stage with a few questions and then you can expand on them at will. So let's get started. So estate planning is really important for all families, but particularly for families when there's a child with a disability such as Down syndrome. And so we're wondering things like how early should you be started? What kind of things need to be considered that might be sort of coming from left field or might not be in the typical wills and estate process?
Yeah, no, and I think that this question is really challenging, I would say, for many families with children with disabilities, including Down syndrome, is how do we get started?
Yeah.
Why do we need to get started? And I think it's really important, initially to appreciate that, first of all, estate planning is important for all of us. We all should be dealing with this. But when you have a child, minor or adult, with, a different ability, you need to start planning for the day when you're not there. And I think that, the starting point for many families is developing peace of mind, that there's going to be a plan when they're not here. And we all know that families and parents with children with disabilities are pretty unique. They're pretty special people. Their siblings are unique. And, that onus on them is extremely overwhelming. So, the starting basis is let's try to develop some peace of mind, because we need to plan for that day when we're not there. But when it comes to the issue of estate planning, the duty is even more heightened. So, as parents, we all have moral duties to our children. We have legal and moral duties to our spouse. And disability is irrelevant in that context. When a family starts to think about planning, typically there are issues that have arisen that have heightened the need for planning. And the most common issue that comes up is that at the age of 18, your child with a disability may be eligible for provincial disability benefits.
Okay.
And with that comes issues around assets and income limitations. And so you need to be cognizant of those limitations. So, for example, someone receiving provincial benefits in BC can only have up to $100,000 in liquid assets. They can own their own home. They can have an RDSP, which is a registered disability savings plan. They can have other sorts of household furnishings, and they can have a trust. And we'll talk a little bit more later about trusts, but those are sort of the what we call the exempt assets that do not impact provincial disability benefits. So if an individual received an inheritance and was receiving provincial benefits and they exceeded those asset limitations, they would now not be eligible for provincial benefits. Right. So your good deed and your moral duty to provide for your child without proper planning could result in a prospective loss of disability benefits. So that's the fundamental, usually that's the reason why families will look to estate planning. But there's more. Aside from disability benefits, there are other more significant issues that need to be contemplated. And the one that I think about probably more so with families with disability is the issue of ensuring that there's protection against vulnerability, susceptibility, and or undue influence. And quite frankly, you may not even have a disability to have that concern. I have a young daughter, and I can't imagine leaving an inheritance outright to her at the age of 19. And I think for family members where disability is in place, that is an issue that they're going to also contemplate. There may also be, issues around capacity. Does the person with the disability have the ability to appreciate and manage or administer an inheritance? And everybody's capacity will be different in that respect. So those are really important. Failure to sort of plan with these sort of factors in mind, where disability is such that capacity is at issue, could create the need for other costs, unintended development, such as private comiteeship, when you have a court effectively declare that person incapacitated, or the possibility of the involvement of the public guardian and trustee of British Columbia to manage an inheritance where capacity of the person with a disability may be in question. That can be very costly. And so it's another incentive to plan, because planning will avoid elements of uncertainty in the future and allow you to control and ensure that the best interest of your son or daughter is going to be maintained, notwithstanding the fact that you're not here, you're not alive to direct that decision.
Right. So what I'm understanding from what you've outlined so far is that this might become an issue sort of on the radar of parents around the age of 18, or around the age that their child would be 18. But in the better case scenario, planning would have started much before this to sort of avoid some of these pitfalls that you're describing.
Absolutely. In fact, planning should never, it's an ongoing process. And it should start, for anybody that's an adult and that has assets that need to be managed, especially when you have minor children, there are additional factors such as guardianship as well that need to be considered, in terms of ensuring that we're planning for the future, but we're also avoiding the prospect that government entities such as the Ministry of Children and Families and or the public guardian and trustee are not actively engaged, in affairs of your family. One of the things that we really sort of emphasize is that families know best about what the needs are of their family. And relying on last resort options such as government agencies to take on responsibility is not good planning and may actually result in significantly more cost. The other thing I just want to touch on that's relevant in British Columbia is wills variation legislation. We're the only province in the country that has laws that actually stipulate that you have this moral duty to your children. And in the context of people with disability, the common question that comes up for many families is, why don't I just leave the inheritance to another sibling who will then take care of the person with a disability? Unfortunately, in our province, that will raise the prospect of a wills variation challenge. Because if you have not adequately planned and provided for a person with a disability who has these moral rights to a share in your estate, there is a very good prospect that your estate will be challenged in court, not necessarily by the person with a disability, but by the public guardian and trustee, who will have an oversight role in the administration of your estate. And it may be they that decides that you haven't provided for your son and daughter properly, and they will go out, retain a lawyer, and initiate an action on behalf of your son or daughter with a disability. And I might add here that the cost of that will come out of your estate. So, we're fortunate in British Columbia where that is not an issue, because there are methods to plan and still provide for your son or daughter with a disability, and at the same time fulfill your moral duty to that child under that legislation.
So it was described to me at one point that not having a plan that the family themselves has designed doesn't mean that there isn't a plan, because in fact there is. The government has planned for you, but it might not be the plan that you want.
Yeah.
It will certainly be a more expensive plan than you would anticipate. So it's not that if you don't do anything, nothing happens. Things certainly do happen. And therefore it's worth it to be prepared in that.
Yeah, I think uncertainty, and uncertainty obviously, breeds costs in various ways, both qualitative and quantitative. And I think that, with any plan, the more direction, the more control you have, you bring also knowledge that other entities won't have. You know your family, you know the limitations, you know what the needs are of your son or daughter with a disability, and who better to make that plan than family themselves.
Yeah. And it kind of leads us nicely into our next question with respect to inheritance. So how does an inheritance by a person with Down syndrome impact their ability to receive that government support? So such as, the disability assistance, or what's known as the Persons with Disability Assistance in BC. So how?
Yeah. So, I think the key point here is that not having a plan, with respect to a prospective inheritance could impact entitlement to those provincial benefits, more so because of those asset limitations. So again, keeping in mind that current $100,000 exemption limit, today in BC, pretty much anywhere in BC nowadays, an estate is likely going to be worth much more than $100,000. And so if if your son or daughter with a disability is receiving those benefits and they receive an inheritance outright, they're going to exceed potentially that
very
limitation.
Easily.
Yeah.
But there are also going to be these other issues. Can they manage it? Do they have capacity? But from a provincial disability benefit perspective, an inheritance that is distributed outright without any planning, so just a straight dollar transaction, could have serious implications for the continuation of receipt of those provincial benefits, just simply because of the rules of provincial disability benefits. Fortunately, again, we have tools. Estate planners like myself have a variety of tools that we can utilize, in conjunction with, permitting a family member to receive an inheritance while at the same time protecting against loss of benefits and ensuring that they're protected against undue influence from other third parties. And again, the list is expanded over the years. There are, of course, the registered disability savings plan which permits you to hold up to $200,000 in a plan. But, more commonly, the utilization of a trust. And I know we're going to talk a lot more about trusts and the different types of trusts, but the trust vehicle, notwithstanding all of these issues, has become and continues to be the prominent tool and vehicle for holding an estate inheritance because of its flexibility, but also because of the prospect of you being able to hold assets that are well above $100,000 and still enable that person with a disability to continue to receive provincial benefits, notwithstanding that inheritance.
Okay.
Right.
So great. So let's jump into that. So for our listeners and myself also, can you explain to us what a trust is and what are some of the different types of trusts?
You bet. I'd be happy to. So, I know that families and people that have, attended sessions like this, get a little bit overwhelmed when we start engaging in the discussion of trusts. And so what I like to do is spoon feed it really, really gently. And put it in sort of plain language so that people understand it. And again, remembering that trust law and estate law is very complex and can be overwhelming for many people. But from a sort of a basic foundation, a trust is effectively a relationship where one person, we call this the settlor, gives assets to a second person, and we'll call that person the trustee, to hold and use those assets for the benefit of a third person, and we'll call that person the beneficiary. And that's traditionally the person with a disability. The great thing about a trust is that trusts, in the eyes of the Ministry of Social Development and Poverty Reduction, which provides provincial benefits, trusts are not treated as an asset of a person receiving disability assistance, and therefore the disabled beneficiary, who is the recipient of trust funds, will continue to qualify for provincial disability assistance. So trusts, provide this opportunity for persons with disabilities and their families to transfer and safeguard their assets while meeting their disability-related costs now and in the future, while we still protect against those vulnerabilities and undue influence from others.
Okay. So, I know that we're focusing a little bit more on the picture in BC, but how universal are trusts? Do the same definitions apply internationally and out of province?
Yeah, well, it's a great question. I know there are various terms that are utilized throughout the country. And I know many folks will have heard of the traditional Henson Trust.
Yeah.
And a Henson Trust is really an Ontario concept.
Okay.
That is very much similar to our discretionary trusts in BC. And what I might do here is just provide a little bit of an overview of trusts in BC, because while we have our provisions in BC, there are definite similarities in all provinces in Canada, and even beyond Canada.
Hmm.
But ultimately, what is important is the interrelationship of trusts in British Columbia as it relates to provincial disability benefits.
Right.
And what's the interaction?
Okay.
So on sort of a broad sort of overview, when we're distinguishing the various trust vehicles, there are a number of terms that I think are important to understand and distinguish. So from a very broad perspective, we have two types of trusts. We have what are called inter vivos trusts, or what we call living trusts. These are trusts that are in place today while the individuals that are creating the trust are also alive. So they're settled. These trusts are settled by a person while they are alive for either their own benefit or for someone else. The other type of trust, which is the more common trust in the context of estate planning, is a testamentary trust, or these are our traditional death trusts. They are generally created in a will, and they are settled after the death of the will maker. So your inter vivos, your living trust, your testamentary trust, your death trust. The big distinction between these two types of trusts is an emphasis on how the trust was created, and more importantly, and this is becoming more relevant, how the income in the trust is taxed. Because remember, a trust is created like a separate entity, and it is treated as a separate taxpayer. So that's sort of the starting sort of basis. And within that context, we then have trust policy. And trust policy is really policy that is issued by the Ministry of Social Development and Poverty that outlines sort of a further sort of delineation of trusts, which are the non-discretionary trust and the discretionary trust. And so these two terms really focus on the powers and the control that the trustees have in managing the assets in the trust. So let me just, before I delve into that, let me just ask if there's any clarity or questions that either of you have.
I'm glad you asked.
Yeah.
I think I understand what you've just said, but let my small brain catch up to yours. So what I understand from what you've said is there are two broad categories of trust. Those for people who are still alive and intend to meet out the trust while they are alive. And those of the other category for the trust that's dispersed after the trust maker has passed away. Have I got it so far?
That's right.
Okay, phew. And then further in detail is the discretionary versus non-discretionary terminology,
right,
where the trustee would be able to potentially change the terms of the trust in a discretionary trust, or
not necessarily the terms, but the exercise of power and control in exercising discretion. And one great way to sort of, to differentiate these terms is through some examples.
Yes, please.
And so, let's start with the non-discretionary trust. So these trusts are trusts where the trustee itself does not necessarily have total authority over how the assets are managed, as the beneficiary with a disability may have some input in the decision making of the trust, either as a trustee themselves or because they have originally contributed assets to the trust. Great example of this is, let's say that grandma unfortunately did not attend or listen to this amazing podcast.
Grandma.
So she has no knowledge of disability benefits and trust laws. And as a grandma would, wanted to take care of her granddaughter with Down syndrome, who happened to be 23 years old and receiving provincial benefits. Now, when grandma developed her will, she actually told her lawyer, I would like you to leave $200,000 directly to my granddaughter with a disability. And the lawyer obliged. And then unfortunately, grandma passed away. And at that point, grandma's estate would have been administered. And unfortunately, well, fortunately for granddaughter, she was about to receive $200,000 in cash. And let's even further assume that granddaughter has sufficient capacity to actually be able to make decisions. So there may be some diminished capacity, but enough that, we're confident that granddaughter could direct us in helping her redirect those amazing funds that grandma left her in another form of an exempt asset that would preserve her provincial benefits, because that's the immediate concern. Is that, oh my, I've received $200,000, but now I'm in a bit of a difficult position because now I've exceeded my $100,000 threshold, which is permitted under provincial benefits. What am I going to do? So granddaughter would come to us and say, what are my options? And so what I would say to her is that, well, first of all, you're allowed to have up to $100,000 in exempt assets, but anything over $100,000 will make you lose your benefits. So what are we going to do? Well, we could take that extra $100,000 and put it in an RDSP. That would be very economic because it won't cost you anything, but it would also mean that you're not going to access those funds until you're 59. And so that may not be your wish. You might want to use that $100,000 to purchase a principal residence. But in BC, and especially in the Lower Mainland, that may not be realistic because a house, as we all know in BC, might be $1 million.
Yeah.
So the other option is that granddaughter could create a non-discretionary trust where she takes the excess $100,000 and puts it in a non-discretionary trust where she possibly is one of the trustees along with, let's say, mom. And so there might be a joint trustee. And that trust fund would be then designed and developed today while granddaughter is alive. She would direct us to actually develop that trust. And that would then preserve her entitlement to provincial benefits while at the same time reaping the benefits of grandma's great gift to her granddaughter. Now, the one thing I will add here is that non-discretionary trusts, while they are exempt assets, have limits as well. The value of a non-discretionary trust pursuant to the provincial benefit legislation has limits that you can only contribute up to and not exceeding $200,000.
Oh.
So you have a bit of a dollar threshold. Now, I will add, though, that there is a provision within the ministry regulations that permits capital contributions in excess of $200,000 if you can get special approval by the minister that your disability or lifetime disability costs will actually be greater than $200,000. And my experience with the ministry is that option, number one, has not been utilized regularly in our province, but we, within my office, have had great success in asking for a higher exemption amount. And generally, the ministry is very reasonable and will grant a higher exemption if you can demonstrate, that lifetime disability costs being higher. And so that's just another vehicle that might assist in that respect. So that is a good example of the non-discretionary trust. So maybe I'll pause for a sec before I get into the discretionary or Henson Trust and just see if either of you have any questions.
So I guess my question for you so far is, even though the regulations are set to be provincial in accordance with how benefits are dispersed provincially, a person who's listening to this from outside of this province or outside of this country could look for these same features and talk about it with their wills and estate planner, things to avoid, things to seek out.
Yeah, so important to be focused on, the jurisdiction in question. And so, understanding how provincial benefits work, let's say in Alberta versus Ontario. Generally, again, there are similarities, but, we're really BC expertise, and it's important that, clients in sort of multi-jurisdictional environments are, aware of, that sort of need to understand the laws of that province. And generally that means, working with a professional who's more familiar with that legislation.
Okay.
And then, I don't want to jump ahead and ask this question if you're going to cover it in the next one, so please let me know. But just in terms of the role of the trustee, would that be different in discretionary versus non-discretionary? Or is there...
Let's maybe we can hold that.
Sure, absolutely.
Because I think what we could do is come back to that.
Yeah.
Because that is a really important issue and one that really deserves a lot of attention. And there are definite similarities in the roles, but I think in the eyes of the non-discretionary trust, just remember that it is effectively a vehicle of policy of the Ministry of Social Development that permits assets that will put someone over that $100,000 threshold into another exempt asset. So it's a creature of regulation. It's not necessarily a trust sort of concept in trust law, but what the key point is that the person with the disability would generally be considered the settler So you remember my definition of what is a trust would be the creator of that trust. But they may also be a trustee themselves or a co-trustee, and they may be a beneficiary as well. So they may fill sort of all three hats of a traditional trust and still not lose their benefits. So it is definitely a powerful vehicle. The other common scenario where a non-discretionary trust might be utilized is where there, let's say, is an ICBC personal injury settlement, and money is awarded by ICBC to a person with a disability. And again, this same sort of practice of developing this non-discretionary trust may serve to preserve an entitlement to provincial benefits. It is premised, though, on the concept that the person with a disability had sufficient capacity to be able to direct a lawyer like myself to actually design that trust. So, one of the starting points in an analysis of this option is whether or not the person with a disability has sufficient capacity to actually undertake the development of an inter-vivos trust. And that may not be possible for everyone. And so we need to carefully consider that. And, effectively what we want to do is encourage grandma to actually listen to this podcast before she does her planning.
Yeah.
I do have some questions for you around that. So am I correct? I'm correct in understanding that capacity is the contingent factor in having this non-discretionary trust.
That's right.
And how exactly is capacity determined? Because I think it's a very relevant question for the population of people we work with.
It sure is. Determining capacity in a legal context is quite different than a medical definition of capacity. So as a lawyer, whether you have a disability, whether you're a senior, with a diminishing level of capacity, capacity is at the forefront of undertaking the development of any estate plan. The lawyer needs to be satisfied that the person understands what they are about to embark on. So in the situation of the creation of a trust, they need to know what it means to set up a trust. They need to understand what the ramifications of that are. The lawyer needs to be comfortable that the person has an appreciation of what their assets are, who the trustees are going to be, and what sort of role and responsibility that they will have in the administration of that trust. They need to understand what it means if they were to pass away and there was a further distribution of the assets within that trust to other parties. What's their wishes? What are their intentions? And do they understand the impacts of those intentions on family, on other parties? So it's more of a conversation that a lawyer would have with the prospective client to assess comfort and confidence that the person with a disability was capable of appreciating the development of that trust. So it's a very difficult environment, but one that, we as lawyers need to undertake. really in any estate planning context, we need to have confidence that those that are retaining us and or instructing us, have capacity to actually undertake, the requisite planning.
Can you walk us through an example where an individual was determined to not have capacity to be able to set up this kind of trust, where they didn't understand the sort of players involved and the legal ramifications and the effects on family, et cetera, and their own future? So in the instance where capacity requirements are not there, what next?
What the scenario is, yeah.
Well, and this is where we get into these, earlier concerns that I expressed. So, if capacity is not in place, and in this grandma situation, if granddaughter wasn't capable of instructing, now we have a situation where we have $100,000 over the asset limit, but we have concerns about granddaughter's ability to manage those assets. So number one, we're likely going to lose provincial benefits immediately, because if you cannot move those assets into other exempt assets, you have now exceeded your threshold for asset holdings, and therefore the ministry will deem you now ineligible for benefits. The loss of benefits is the immediate concern, but the more, significant concern is, if we don't have capacity, how do we manage those assets? Who has legal authority to manage those assets? And that in itself may necessitate the need for a court-appointed guardian, if there is in fact, and there would be no ability to have a power of attorney. And I know we're going to talk about some other vehicles later, but if there is no sort of appointed guardian, we're now left to the prospect of the need for private comiteeship, which is a very expensive court application to ensure that there is somebody that can manage that inheritance for granddaughter. And that may involve the need to, go to court and get an order declaring granddaughter incapacitated.
It's terrible, but what comes to mind is the Britney Spears case. I'm just going to say it. It's the conservatorship issue.
Yeah.
That's terrible, but that is what you're describing.
Well, and this is why, we try to educate, families to plan, because, these are one of the unintended consequences of, someone like grandma who has great intention and great love for her granddaughter, but didn't get proper advice and didn't have a better understanding or appreciation for what this good-hearted, decision was and what the impact was. A private comiteeship application is a very significant undertaking, and the costs can be significant, starting at anywhere from $7,500 and going up. So that good-hearted decision may have actually now created unintended financial consequences.
So from what I've understood is, not only should there be money plans in place in advance, but potentially also guardianship plans in place for adults who would not be determined to have capacity.
Well, and this is where I think this is a great segue to the other trust, which is the discretionary or Henson Trust, which to some extent incorporates within it guardianship principles, because there's a presumption that the person with a disability may not have capacity. So maybe I could just get into that a little bit here and just talk about the other trust, this sort of Henson or discretionary trust.
Perfect. Yes, let's do that.
So one of the great benefits of, this trust to a person with a disability is that this trust will allow a beneficiary to continue to retain government benefits while, again, receiving funds from the trust at the trustee's full discretion. These trusts are generally created within a will. And so when mom or dad passes away and they leave funds to their disabled daughter, they may put those funds in a trust that's deemed to be fully discretionary. And again, in these trusts, the trustee has ultimate control about how the funds in that trust are distributed for the benefit of the person with a disability. These trusts will only take effect when the person that created the trust has died. And that's that testamentary sort of element. The one amazing benefit of these trusts in conjunction with provincial benefits is that there is no limit to the amount of money that can be held in these types of trusts. You can have millions of dollars in a fully discretionary Henson type trust, and the person with a disability will continue to receive provincial benefits. That is a huge attraction, especially in BC, where estate values are generally much more than a couple of $100,000. So, and in the eyes of the ministry, the reason why the ministry has said that these trusts can have unlimited dollars is that the person with a disability is considered to have no beneficial interest in the assets held in the trust or a right to income from the trust, and no ability to demand estate capital. The beneficiary is considered to effectively not have an asset because they have no ability to actually control the asset. And therefore, the ministry says, well, if you don't have that ability to control it, then you do not have an asset. And because the trustee ultimately is responsible for managing that trust, you now have an exempt asset, and you can have, $1 million trust of this nature and still receive your provincial benefits.
So
Much
in a
higher
lot of
amount.
cases, this is preferable.
Yeah.
Yeah, and I would say that, this is the more common vehicle that is used. Again, understanding that while you have sort of unlimited holding capability in this trust, and you're not going to lose your benefits, the downside is that the person with the disability is ultimately at the mercy of the trustee. You need to have confidence that the trustee, and we'll talk about trustees soon here, that the trustee is going to be able to make decisions that are consistent with your wishes. And generally, though, trusts are designed to be broad and discretionary and to provide some guidance. But generally, we don't want to overly restrict a trustee. We want them to be able to provide freely as life unfolds for that person with a disability. There are things that, we can do to help sort of further guide a trustee, whether it's providing, specific outlines of wishes in a trust that may be more binding. But there are other remedies, such as a more informal letter of wishes that is more of a supplement to the trust. Something where you again might state in a letter, what are some of your goals for this trust fund when you're no longer here for your daughter with a disability? And you may provide some informal, non-binding guidance to a trustee that says, I would really like you to ensure that my daughter always has a roof over her head. I want to ensure that there's always groceries available so that she has nutritious meals. Maybe it's an annual trip to visit grandma in another province. Flexibility, I think, is the key. And the more knowledge that a trustee has, the better they're going to do their job.
Right.
So if I'm understanding correctly, then with a discretionary trust, there's a little bit more flexibility in how it can be used, correct?
Well, it's broad. I mean, generally they're broadly designed to provide, ample authority. And, one of the challenges in designing a trust is that although I feel like I can predict some of the future, I'm definitely not an expert in the future. And what we want to be able to do is give that trustee sufficient flexibility to make decisions not only tomorrow, but maybe 30 years from now,
right?
When we don't know what the world is like. We don't know what the needs are. And so we want to provide, enough flexibility that doesn't unduly restrict the trustee in managing the trust, providing for the person with a disability, while at the same time understanding that we don't want to be in a position where you might need to go to court to have a judge provide an interpretation. So we're trying to avoid unnecessary costs.
Yeah, that makes sense. Yeah. So, well, then maybe let's just pivot a little bit more back towards my question earlier about the role of the trustee.
Yeah. Let's talk about that a little bit. So, with respect to the role of the trustee, I guess the first thing I will say is that, and we'll talk about, some of the factors maybe to consider in choosing a trustee as well. But the role of the trustee is a very significant element of that plan. And obviously, choosing that trustee is fundamental. And so, from a very basic high level overview, that trustee is going to have significant fiduciary responsibility. They're going to be charged with managing and administering the trust according to the terms of that trust deed itself, along with an understanding and appreciation of the needs of the person with a disability, while at the same time being mindful of these duties, pursuant to the provisions of the Trustee Act of British Columbia. They're going to need to keep accurate records on a timely basis and be ready to account for all matters associated with the administration of that trust, including receipts and disbursements of funds. They may have a duty to report that to both the ministry as well as the Canada Revenue Agency if there was ever an audit. They're also going to have a responsibility, to invest the trust funds as a prudent, and reasonable trustee. And again, they're going to have a number of other duties such as filing tax returns and other administrative duties. And I'm only skimming the surface here. And so, with that responsibility, there's also a need for time and expertise. There's a need for, an appreciation of the interrelationship of provincial benefits and trust law, that will make that job very, very challenging. So I think, the role of the trustee, I know that folks used to, might say, well, I've been appointed a trustee. And I can tell you that it is not an honor. It is a significant, it is a significant obligation fraught with an amazing amount of liability and responsibility. And, we're all busy individuals. We have families, we have careers, and to embark, on this role needs to be carefully considered. And I think, the starting point is a dialogue between your trustee and yourself, to assure them that they're capable and willing to assume that role.
In your experience, are trustees generally family members, or is it someone that is more objective, or is it a mix, or is there something to think about when they're making that decision?
Yeah, I think all of the above are considered. I know that families, obviously they want to have initially trust. They want to know that that person knows their son or daughter. That's going to be there for them. More and more, I think there's also recognition that while we may have somebody in mind today, it's possible that this trust will be around for the life of your disabled son or daughter. So if we're talking about a trust, that has, let's say, a 50-year life, we need to plan for the prospect that who you might be thinking about today may not be here or available or willing 30 years from now. So the job of both you and your lawyer is to come up, with a succession plan. And so, more and more families are looking beyond family and friends as trustees and understanding that they may need to consider a professional, such as a corporate trustee, somebody that, you have some confidence that will always be around to provide that service, and that your son or daughter won't be left with a trust without a trustee. Now that obviously bridges more questions, and that is around the whole issue of, the costs of bringing in a corporate trustee.
Yeah.
And that adds more, to that equation, recognizing that whether you have a professional or a family member as trustee, trustees are always entitled to trustee fees under the provisions of the Trustee Act. And, a professional will definitely add a different layer of knowledge and expertise. They will also be more highly regulated, and therefore their duties will be, strictly monitored as well. And so, it's I'm sure we could actually have a podcast just on trustees alone, because it is such an evolving and important area. And I think it's probably what, once a family member has decided to initiate their plan, I think the choice of trustee is probably the biggest issue that arises for families with disability. And it's probably what creates a lot of the delays and the procrastination, is what individual, and I like to use the word, what army of individuals
yes
is going to do what I do today.
I was just going to ask you about that. So I would like to talk a little bit about the possibility of having more than one person in the role of trustee. So if let's say you hire a professional to administer and disperse the funds, and then do you include maybe making more of a board or a micro board where you're including other people who have greater knowledge of the person with a disability and are able to add their own personal knowledge into the decisions made on this trust?
So, I think, the concept of, again, trust, and appointing, what might be somebody that's unfamiliar with your son or daughter, i.e. having a corporate trustee that just may not be aware of your son or daughter's needs, may cause one to reflect on the need to perhaps have a co-trustee environment where you might have a sibling or an uncle or a friend acting in a co-trustee role with a professional administrator, so that you now have two trustees, one that has this sort of family and or knowledge of the person with a disability, who understands what their needs are, and then at the same time, a corporate trustee that you can rely on to fulfill, the legal and administrative duties of that role. And so you can delegate responsibilities. And I think for a lot of families, having that sort of familiar sort of entity as part of the dialogue and in terms of decision making provides some checks and balances as well on a professional that doesn't know the family or the person with a disability. And so that's another real common approach that a lot of families will utilize in appointing trustees, is that they'll sort of differentiate between, what the responsibilities are.
Okay. And I think that's really encouraging for families to hear, that you don't have to choose a one or the other. And if you can pull together your sort of group of like-minded people, you have a good option there. Hinda, you had another question.
Yeah, I was just gonna, while we're on the topic of trustees, I had a couple more questions that I think our listeners would be interested in. So, Ken, you were talking about the levels of money for discretionary, non-discretionary, and the different levels of trust, what limits are there on how money in a trust can actually be used?
Yeah, and again, this is a really, again, another complex area, because setting up the trust is one thing, but ensuring that your trust is being administered in compliance with provincial disability benefits is also as important. And knowing that your trustee understands, what those limits are. And so within the trust, we would try to provide some guidance to a trustee. But generally, the limitations are outlined specifically in the disability benefit regulations. And there are a number of categories that permit expenditures from the trust. And so I'll run through these with you. There's the ability to provide expenses for caregiver services or other services related to that person's disability, education or training, home renovations necessary because of disability, home maintenance repairs, medical aids, and then this final category, which is sort of the catch-all, which is any other items that the trustee or beneficiary considers necessary to promote the person's independence. Now, what does independence mean? That's a very broad concept. And as of a few years ago, the ministry recognized that they have no expertise in what is independence, and that responsibility lies on the trustee and the person with a disability. So independence is whatever you think is independence. And it may mean that, it's a membership in a fitness club. It's a trip to Mexico every 2 years when we can fly again. It's tickets to a Vancouver Canucks hockey game. It's a broad spectrum. And so it's a very useful tool to provide disbursements. Now, one of the things I will add, though, those first 5 categories that I mentioned, one of the challenges and one of my frustrations with these permitted expenditures under the regulations is that if somebody is receiving provincial benefits, they're likely going to be eligible for supports and resources through the provincial government, through other ministries. So a good example of this is home care or, CLBC funding. So the question, of course, is, well, why would you use a trust fund to pay for those costs if the government is already going to provide that? Those are things that trustees would need to be aware of so that they exercise caution. And again, a good drafted trust will acknowledge that a trustee may not have that expertise. And so language would be embedded in the trust to ensure that the trustee was aware that they should make efforts to explore other resources that might be available to the person with a disability and not immediately jump to using the trust fund, and rather save the trust fund for expenditures that are not funded by government and use that category of independence as a tool. The other thing I'll just note is that effective December 1, 2015, there is now no limit on the amount of dollars that can be expended from a trust for purposes of independence. So if you wanted to use the entire trust fund, you could do that, and it would still not disentitle the person with a disability to provincial benefits.
Mm-hmm.
It goes without saying that a trustee, if they don't have sufficient knowledge from the trust itself, that will guide them in maintaining benefits, there is a duty on them to go out and get the expertise. And it would not be uncommon for a trustee who might be unfamiliar with the current day's, disability benefit regime, to seek some guidance from someone, proficient in that area,
Mm-hmm.
to guide them. And, those expenses would be considered legitimate and reasonable costs of the trust, to maintain. I'll share another example in the context of provincial disability benefits and a trustee, dispersing funds. I've had trustees come to me and say, well, can I just give the person with a disability $500 a month? What does the trust fund to do with it as they would like? Unfortunately, the disability benefit regime would consider that $500 to be deemed to be unearned income. And unearned income, which is basically any income that is not employment income, would be deducted dollar for dollar from that person's monthly benefits. So that goodwill gesture of providing $500 in cash to the person with a disability would actually have a penalty effect on the person with a disability, because now they would have effectively lost their benefits. So the more appropriate approach for the trustee is to distribute assets out of the trust to third parties, not directly to the person with a disability, but to a third party, such as, let's say, a travel agent to fund the cost of a vacation, to the Vancouver Canucks Hockey Club to fund the cost of tickets.
Mm.
And there are things that your trustee might also do to sort of manage that, where you still want to provide, let's say, some independence to the person with a disability, and assuming that they have capacity. A trustee might purchase, a $200 gift card for Safeway to enable the person with a disability to use that card to go out and purchase groceries, or a Visa card with a limit of, say, $200 to go out and purchase, clothing, for example.
Mm-hmm.
So there are things that can be done to ensure that, you're maintaining the intentions of the trust. You're attempting to preserve provincial benefits, and you're, aware of the limitations of the person with a disability and their capability, to engage in discussions. And so, this is where the expertise and the time commitment of that trustee, are so important in terms of fulfilling their duties, but not actually creating, more challenges for the person with a disability.
Yeah. I mean, and you covered a few factors in just right now of some of the things to think about when you're choosing a trustee. Are there any other things that you would like for families to kind of think about before they
Yeah, I mean, I think, obviously, and I think I may have alluded to this earlier, the age of the beneficiary, the person with a disability, is, significant. And, an understanding of how long the trust is expected to last. If it's for the life of that person, then we need to know that there's going to be a confidence of a succession of trustees. So, that naturally leads to an analysis of, if it is a family member or a friend, what's the age of that trustee or alternate trustee? Are you appointing grandfather who's already in his 80s? Well, that doesn't provide longevity. How many trustees should you have? What are the provisions, if any, for alternate trustees? Again, I find this one really big. Does the trustee know you and your circumstances? And, do you trust them? Do they have a relationship with your son or daughter with a disability? What about the ability to remove and replace trustees or the ability to permit them to resign? Again, does the trustee have knowledge of disability benefits? Where does the trustee live? Are they in BC? Are they in the United States? What are the implications of that? And then obviously, the size and the complexity of the trust itself. Does it require a professional versus a lay member? And then the final thing, and this one is a bit of a difficult matter, the issue of, possibly avoiding a perception of conflict. Many, many families, and again, good-hearted, will choose a sibling to be the trustee of their disabled brother or sister's trust. And so, and they'll go one step further and they'll say, well, if the person with a disability should pass away, the survivor benefit of that trust fund would be the trustee sibling without a disability. And so what that does is it embeds in the trust a perception of conflict. And I use that word very strongly. It's a perception. It doesn't mean that sibling is going to do anything improper, but it provides the foundation of potential conflict where you're managing a trust and you hold all of the discretion. And if you choose not to distribute, which you're entitled to do, and you are now the ultimate beneficiary of that trust fund, there's an apparent conflict in that context. Again, it doesn't mean it's wrong.
Yeah.
And 99% of families, that would be a good environment. Unfortunately, I get to see the 1%.
Yeah.
And that 1%, could be a problem.
Yeah. When it may not be intentional in terms of how you have it set up, but to the public, it might be perceived as something that may not be.
Exactly.
Yeah,
and remember,
that's a good point. Yeah.
And remember, the person with a disability, under the context of that discretionary trust, will be at the mercy of that trustee. They will not be able to demand a distribution.
Yeah.
And so, that's where, where you have that situation, you may supplement it with, say, a sibling, and now maybe a corporate trustee, to find some balance.
Yeah, makes sense. It's a really great overview. I think I continue to remind myself that this is a very complicated topic with so many different layers and so many different contingencies to think about. So I really appreciate you kind of laying it out there and providing those examples, because I think it'll hit home with our listeners a little bit more.
Yes.
But yeah, Marla, did you want to kind of
Sure.
pivot to wills a little bit?
So
Yeah.
I wanted to redirect us because this trusts and trustees are one aspect of wills and estate planning, but not the only thing. If that were possible, it's more complicated. So let's pivot a little bit and talk about wills. Can wills be used to contribute to a child's RDSP?
Yeah. And I would expand wills to include trust, because obviously the trust is embedded in the will. And so, again, registered disability savings plans are an amazing vehicle. And number one, I would encourage all families that don't have an RDSP to go get one, because they're an amazing investment tool. But yes, by all means, it's very common to design the trust, the will, to provide for contributions to an RDSP. And it's something that's important, because for those that may not have financial capability to contribute to an RDSP, a trust or a will can provide some supplemental funding that will result in further receipt of federal grants and bonds that will further provide for, the retirement and the aging of that person with a disability. So definitely an RDSP, in my mind, should be strongly integrated with the concept of estate planning on a will or a trust.
Okay. And that's something that can be done well before the age of majority, if I understand correctly.
Yes, absolutely. In fact, not only can you, just start it, you may even be able to retroactively recapture years where you didn't contribute, but you were eligible to contribute. Again, an RDSP is perhaps a future podcast, and I believe you may have done one.
We have one
recently, so that would be a recommended listening for your listeners.
I want to touch briefly too on a couple of other legal documents that are prepared in conjunction with a will. Can you explain the purposes of things like power of attorney, healthcare representation agreements, and why families might need these as well?
Absolutely. And I'll again just highlight that this is a topic within itself as well. A lot of families and a lot of us only think about dying. And I'm a big believer that we should also be thinking about living. And we're all living longer, notwithstanding the pandemic. And because of that, we need to think about tools that will allow us to, live, but also accommodate changes in our lives. And so the big distinction between a will and these other documents, the power of attorney and the healthcare representation agreement, is that a will is all about dying, whereas a power of attorney and a representation agreement is all about living. They're only valid while you're alive, and when you die, they die. The power of attorney is predominantly a financial and legal tool. It allows you to appoint a representative called an attorney who will be able to manage your financial affairs, your legal affairs, either today while you're alive and you have full capacity, and or if you lose capacity and can't make decisions up until the point of death. The important element of the power of attorney, though, is that much like a will, you need to have capacity.
Mm-hmm.
You need to be able to understand what it means to develop the power of attorney, what it means to appoint a person to manage your affairs. And so these documents may not be available to our disabled children where there may be capacity issues.
Mm-hmm.
The other vehicle is a representation agreement. And the one that is focused more on healthcare is the Section 9 representation agreement, which provides the ability to appoint a representative who is then charged with managing and assisting you in making healthcare decisions. Again, the capacity requirements are similar to the power of attorney. You need to have capacity. Now, I want to touch on family members with a disability in this context because that comes up quite regularly. Well, my son or daughter is now 19 years of age, and I no longer have guardianship responsibilities. They're adults. And when you're an adult, there's a presumption that you're capable of making decisions. We, of course, know that, due to aging, disease, or disability, not everyone's going to have that capability. And so for families, with adult children with disability, we're also very fortunate to live in a province which permits those with more of a diminished level of capacity to be able to create what is called a Section 7 representation agreement. These documents will permit your son or daughter with a diminishing level of capacity to appoint a representative to help them manage routine financial, legal, and healthcare decision making. And that can be very, very empowering to know that the person with a disability, while they might not be able to, create these documents like a power of attorney or a Section 9 agreement, representation agreement, they're going to be able to have the ability to appoint a representative that can help with more routine matters, such as, daily banking,
Mm-hmm.
managing CLBC funding, managing home care, deciding where they're going to live. So more routine related.
Mm-hmm.
And that is empowering because it avoids the prospect of possibly committeeship, which I talked about earlier,
Mm-hmm.
which could be very costly and it may be unnecessary.
Right.
So this is a really important document. And, I would encourage families when their children reach the age of 19 to consider at a minimum the development of a Section 7 representation agreement. And there are a number of resources out there, and I know we're going to talk about resources,
We are.
but I would strongly encourage the NIDIS registry as a vehicle to assisting a family member with diminished capacity in designing and developing a Section 7 representation agreement. The other thing is you don't need a lawyer to develop a representation agreement. So, access to justice is really at the forefront. And these documents are recognized by all levels of government as prudent methods of planning for a family member with a disability.
That's actually really good to know. I would anticipate and entirely understand if someone listening wanted to have a lawyer to help them work through some of these very complex topics that we've been chatting about for the last little bit here. Do they need to seek out a particular type of lawyer if they're involved in this sort of planning for a person with a disability? Can they just walk down the street and find the first person they see? What should we look out for?
Well, I think the first thing to recognize is that not all lawyers understand wills and trusts. And not all wills and trusts lawyers will understand disability issues. So it is absolutely crucial to find a lawyer who understands disability issues as they relate to your estate. And, I think like any investment, like any advisor, you're going to want to do your research. You're going to want to ensure that you seek someone that is expertise in this area and that they're going to be able to guide you through this very challenging and complex area of law. But you're also going to want to know that they're going to get the job done. And that peace of mind that I alluded to at the very beginning is so vital. And unfortunately, if you decide to pursue, someone that doesn't have this expertise, but is trying their best to help you, a mistake now can be extremely costly in the future if it's not done properly. So, consider it an investment. And I know, cost is obviously an issue that is on everyone's mind. Costs are going to vary. But, the value of the knowledge and the experience in setting up these trusts and a strong appreciation for that interrelationship of benefits is going to go a long way, to providing that peace of mind. Price is obviously important. Everybody has a budget, and it's really important to ensure that the plan adequately addresses your specific family and your circumstances. Whether it's a low price or a much higher price fee, that doesn't necessarily equate to expertise. And it may be that, even the high priced, product may have holes in it.
Right.
And so you want to do your diligence, speak to organizations like this organization and others that have families that have utilized lawyers with expertise. Interview several of them like you would with any advisor. Make sure you have comfort in their expertise, and do your diligence. Ask a lot of questions, and use this podcast as sort of a vehicle to ask questions. And if that person doesn't have the ability to respond adequately to those questions, now that you've got some more of a foundation of knowledge, then go to the next advisor until you find the right
time
fit.
to gamble. Yeah, exactly. Exactly. To wrap things up here, I would love if you yourself would be willing to suggest some resources that people could sort of enhance the knowledge that they've started today. Is there a particular website or websites or individuals that you would recommend seeking out?
Yeah, I mean, there's several. Obviously, the BC Ministry of Social Development and Poverty Reduction has an information booklet called Disability Assistance and Trust, and it's a very good initial read on this sort of interrelationship of trust and disability. It's not legal advice. So their website is gov.bc.ca/SDPR. The other one that I would highly recommend is Planned Lifetime Advocacy Network, or PLAN. And PLAN is an amazing organization, much like this organization, that provides amazing sort of supports for families with disability. Their website is plan.ca, and they have, workshops on this topic that you can attend. We talked about NIDIS, the NIDIS registry, and they're at nidis.ca. And again, they're really experts in guiding families around issues such as personal planning, representation agreements, and powers of attorney. And then finally, I'll plug my own website.
Do that,
KMK Law. Our website address is kmklaw.net. We have a blog on our website with a host of articles that I've written on this topic. And because I've done hundreds of presentations on this topic, there are also videos of sessions that I've actually presented on the topic of disability and estate planning, as well as personal planning, that you can actually view on our YouTube page as well, so that if you want to have a bit more of a visual experience, you can actually watch those in your home at your leisure, and refresh your memory on what we discussed today. So that's a great resource, and it doesn't cost you anything.
And that's a great way to start too, because this is certainly not getting done in a weekend. It's going to take some time and probably multiple reviews of the information.
Yeah, I think that's a really good point, Marla. I mean, the intention here, I think, is to provide a little bit of knowledge to help you develop a foundation of expertise, so that you can now go out and start to embark on the development of this plan. And you're right, you're going to want to digest it, think about it a little bit more. But I think the other thing that I'll just encourage, because I know that this can be overwhelming for families to actually now be in a position where they may have more knowledge, but they still may put it off. And I think the important thing to remember is you're not going to necessarily do this on your own. Getting supports, getting professional advice is going to get you moving forward. And if you have doubts, rely on the advisor who has the expertise to get you directed and to move it so that this is getting done. Ultimately, not having this plan can actually be more dangerous than not having a plan. And so, I encourage families that are unsure, to get the supports, whether it's through your organization, through family, mentors, and others that can, support them, as they embark on what is a very big decision in their lives.
Mm-hmm. And I think similarly after recording our podcast with about the disability tax credit and RDSPs, I feel like even if we can just have this on parents' radars, because I'm sure, RDSP and disability tax credit's a bit of a different thing because that's something you can think about early on, but a lot of parents don't want to broach the topic of wills and estate and trust planning, but that's one of the things that you've highlighted today, that it is important to think about it and have it on your radar early on. So I think that's definitely
and there is a plan. It just might not be your plan. So
exactly.
Make sure that it's your plan.
Make sure it's your plan. Have control over it, right? Exactly. Yeah.
So true.
Absolutely.
So true. And I think, I think that empowerment of knowing that you've done it, I know just from reflection, families will come in to my office and just be extremely overwhelmed with the process and leave that office once everything was done, just feeling so relieved that they've done this, that they've accomplished this, for their family, for their son or daughter with a disability. And I've had family members call up and say, I actually sleep so much better now at night, knowing that I've done this. And I wish I would have got to it much, much earlier.
Yeah, absolutely. Great.
I think that's a good sentiment to end the episode on. We really appreciate you coming to talk to us today and putting this information out there along with the resources that people will need to get started. So thank you so much, Ken.
Yeah.
It's been an absolute pleasure. I thank you for the opportunity to share with families and to hopefully provide a little bit more knowledge today. And welcome the opportunity to assist this wonderful organization again in the future.
Yeah,
right,
for sure.
It.
Thank you so much.